So without further ado, I want to call upon Mr. Ramesh Maharaj. And before doing so, I want to say, yes, he's former Attorney General of Trinidad and Tobago. I think he was Attorney General before he took office because he has always been the guardian of the welfare and the interests of the rights of people in Trinidad and Tobago. So before he became Attorney General officially for state, he was already performing that function in the interests of Trinidad and Tobago. I will say more about Mr. Maharaj after, but I want to welcome him to the podium so that members of the media will hear what he has to say. Thank you.
Sitaram, good morning to everyone. The Dharmacharya, Pandit Rampasad, I don't know why I forgot yesterday. Pandit Rampasad Parasram, the President of the Sanatan Dharma Maha Sabha, Mr. Rambali, the Secretary of the Sanatan Dharma Maha Sabha, Mr. Vijay Maharaj, Mr. Danish Rambali, Member of Parliament, members of the media. Let me say at the outset that I decided to have, in order to be here this morning, in order to explain the importance of the judgment given by the Judicial Committee of the Privy Council in this matter. I think it is important for me to do that because it could be misconstrued in the light of the fact that the Privy Council did not grant to the Mahasabha the constitutional law reliefs that they asked for. If you remember, the Mahasabha asked for the relief for a declaration that the sections, the impugned sections of the Sedition Act were unconstitutional. And they asked for that because the sections of the Sedition Act which permitted the police to arrest and prosecute and search people's home, we contended that that section was vague and it was incomplete, and it gave the police too much of power. The second relief we asked for was that the sedition laws, those sections, were inconsistent with a sovereign democratic state which was guaranteed in Trinidad in Section 1 of the Constitution for Trinidad and Tobago to be a sovereign democratic state. But the contents of this judgment are very important because, as I would show you, the contents of the judgment gave to the Mahasabha and gave to Mr. Maharaj and gave to Mr. Vijay Maharaj, who succeeded in the action, the common law relief that we were asking for in order for the sedition offenses in Trinidad and Tobago to be reformed, to be amended. And what the Privy Council did, the Privy Council used its common law powers to imply in the statute of Trinidad and Tobago words that we were saying should have been included in the act. Now let me explain something to you. There are two kinds of law-making powers. The Parliament, which makes an act of Parliament to make a statute. That is called statutory law. The judges, in interpreting the statutes, they interpret the statute and they can make common law. So what the Privy Council did in this case, they said, we cannot hold that there was a violation of constitutional rights because the Constitution said if there is an existing law, that is, if there was a law which was in existence before the Constitution came into force, even if it violated the Constitution, the court had no power to declare that law unconstitutional. The sedition law was passed in Trinidad in 1920. So the Privy Council said, we cannot use the Constitution to declare the sedition offenses unconstitutional. But what we can do, we can use our powers to declare that from now on, if anyone has to look at that law, that we would imply that you cannot have a sedition offense unless there is an intention to cause violence or to cause public disorder. And I will show you that was the submissions and that was the case that we wanted to be got from the Privy Council by constitutional relief, but the Privy Council said we cannot give you constitutional relief, but we will give you common law relief. Now, I think most of you would know that this is the same law that Mahatma Gandhi was prosecuted in India under, same law under which he was prosecuted in India. And at that time, when there was British rule, and he was prosecuted under the same law, same words and everything else, he took the position that I did not commit an offense, he did not commit an offense. He was preaching peace. He did not incite violence. He did not incite public disorder. And you cannot lock me up, you cannot prosecute me, you cannot jail because I make statements which bring hatred to the British government, which brought contempt to the British government, which brought disaffection to the British government. And the judge, when he was passing sentence on Mahatma Gandhi, said, I wish, words to the effect, I wish I did not have to do this, but the law required me to do it. It is in that context that over the years, over the hundreds of years, since the sedition laws were introduced in England in the 1600s, for over 400 years, there have been countries in the Commonwealth fighting to get that law changed. In some countries, you would see, they did not repeal the law, but they had the law amended in order for the law to read that you had to have an intention to incite violence or you had to have an intention to cause public disorder in order for the law to be good law. What I want to do is that I want to go through some of the facts of the matter and then I will explain the judgment of the Privy Council. My first duty, however, is to pay tribute to the late Satnarayan Maharaj and his company, Central Broadcasting Services Ltd, for the claim they filed against the state following the unlawful search by the police of the company's premises and the unlawful seizure by the police of the tape recording of the statements he made on his call-in radio program on Radio Jagriti, the Maha Sabha Strikes Back. The police claimed at that time that the statements which Mr. Maharaj made on the radio program, the police had reasonable cause to believe that he committed the offense of sedition, and they searched his premises in order to get evidence to support such an offense. Sat's position was that the statements he made on the call-in program, which the police was investigating, was not seditious, that he had a right to express the views he expressed. People may have disagreed with his views, but the freedom of the press and the right to free speech permitted him to say what he said. He claimed that the police, as part of the state, violated his constitutional rights to enjoy the freedom of speech and the freedom of the media. Sat felt he had a duty to file a claim against the state to challenge the actions of the state taken by the police because freedom of speech was at the heart of democracy and the freedom of speech and expression were guaranteed by the Constitution of Trinidad and Tobago in Section 4 and 5 of the Constitution. It was also clear to Sat and the members of the Maha Sabha that the police was going to prosecute Sat for sedition. Sat knew that under British rule in India, Mahatma Gandhi was prosecuted for sedition. He was jailed under the same sedition laws by the British in India at that time. Those sedition laws were introduced in Trinidad and Tobago in 1920. He knew that Mahatma Gandhi was unlawfully prosecuted, and Sat did not mind making a jail for standing up for the people like Mahatma Gandhi. But we decided otherwise. And therefore, it was in that context that a constitutional claim, as Mr. Rambali said, was filed in order to challenge the law. And because that claim was filed, the police decided not to proceed and to await the determination of the case, because the case challenged the constitutionality of the law under which the police wanted to act. SAT took the position that the definition of sedition and seditious intention under the Sedition Act were vague and incomplete. It gave a wide discretion to the police to prosecute persons, to harass persons, and to execute search warrants when they make strong criticism against the government. He felt it was important for him to stand up to fight the battle so that generations after him would not have to fight that battle. I would say today that Sat was right. He fought the battle, and as I would show you, he won the battle, notwithstanding that he did not win constitutional relief, but he won common law relief. He took the position that the definition of the offense of sedition made it possible for the police to charge an individual for sedition if, as the Act states, the person merely used words or published words which brought hatred or contempt to the government, or which excited disaffection against the government, or which excited disaffection against the House of Representatives, or raised discontent or disaffection against the government, or endangered or promoting feelings of ill will or hostility against the government. He took the position that people were entitled in their free speech to excite disaffection, excite hatred, and condemn a government. Its position was democracy, the rule of law, and the guarantee of the freedom of press entitled him to make the statements he made, even if they promoted hatred against the government, or contempt against the government, or excited disaffection against the government, because free speech, even if it offended the government, was essential to have a democracy. Sat felt that Trinidad and Tobago, when it was a colony, the sovereignty of the power of the people resided in the Queen. But that principle changed when the country became a republic. You see, under the Queen is the head, and the Queen is not elected. The King or the Queen of England, the lawyers could do no wrong. Sat took the position, however, that when Trinidad and Tobago became a republic, the sovereignty of the people did not reside in the Queen or the King, but it resided in the people. The people elected the president as head of state through the parliament, and therefore the sovereignty then resided in the people through the president. The people elected the president. That is to say, the people elected a government, and the government in power, through its majority in the parliament, elects the president. He was of the belief, therefore, that if the sovereignty of the nation resided in the people must have a right to condemn the government, because the government is government of the people, by the people, and for the people. Sat therefore saw a difference with the sedition laws being applicable under colonial rule and the sedition laws being applicable under the Constitution of the Republic of Trinidad and Tobago. It was in that context that Sat challenged the provisions of the Sedition Act as being unconstitutional. And he challenged that the police did not have any right to search the company's premises, and the police did not have any right to take his recordings, and the police did not have any right to threaten to prosecute him for sedition. Now, I just want to explain something to you before I go into the depth of the case. The Constitution of Trinidad and Tobago in 1960 and the Republican Constitution also included sections which guaranteed human and fundamental rights. In sections 4 and 5 of the Republican Constitution, it guarantees basic human and fundamental rights. Those fundamental rights which are guaranteed include the freedom of speech, the freedom of the press, the freedom to express political views. His claim, therefore, was that the search of the premises of the company and the seizure of the articles taken by the police violated his constitutional rights under sections 4 and 5 of the Constitution. The written Constitution of 1962 and of 1976, in section 14 of the 1976 Constitution, gave to the people of Trinidad and Tobago a new remedy which they did not have before. And that remedy was to go to the court, and if they believed that any of their constitutional rights was violated by the state, the High Court, the Court of Appeal, and the Privy Council had the right to determine whether the government, the legislature, or the judicial arm of the state violated the Constitution. So it was in that context that Sat Maharaj alleged that his constitutional rights were violated because sections 4 and 5 of the Constitution guarantee the right to freedom of speech, guarantee the right to express political views, guarantee the right to express his thought and freedom of expression, and guaranteed his right to the freedom of the media. So he claimed that these sedition offenses and the actions of the police were violating his constitutional rights because of sections 4 and 5 of the Constitution. He also stated that not only section 4 he was relying on section 1 of the Constitution, which guaranteed to everyone in Trinidad and Tobago that Trinidad and Tobago shall be a sovereign democratic state. And section 2 of the Constitution said, if any law in Trinidad and Tobago was inconsistent with that section, then the court can declare that law null and void and of no effect. So SAT contended that the sedition offenses and the sedition laws, sections 3 and 4 and 13 of the Sedition Act, was inconsistent with Trinidad and Tobago being a sovereign democratic state, because in a sovereign democratic state, you cannot lock up people, charge people, and arrest people for merely using free speech to criticize the government. His position was that if I incite violence, or if I incite, you have a discord in the country, violence means, then the words can be prosecuted, but not mere speech, mere exercise of freedom of speech. It would be demonstrated later in my presentation, based on what the Privy Council said, that notwithstanding that the Privy Council did not grant constitutional relief, the Privy Council found that the definition of the sedition offenses as described in section 3 of the Sedition Act was defective, was deficient. And what the Privy Council did, the Privy Council said that it is entitled to imply into that section that it must, a prosecution must require an intention to incite violence or public disorder. In effect, what the Privy Council decided, that mere speaking of words as described in the Sedition Act cannot amount to unlawful conduct. Now, I want now to go into the particulars of the challenge that SAT made to the sedition laws. So it is clear from the facts of this case and from the judgment given by the Judicial Committee of the Privy Council that the late Sat Maharaj challenged the state on an important point of constitutional law. and in respect of a law which adversely affected the right of individuals to exercise their human and fundamental right to freedom of speech and expression, and to freedom to express political views. I just want to, yes. These are all rights, as I said, which are guaranteed in sections 4 and 5 of the Constitution of Trinidad and Tobago. They were in the 1962 Constitution, and they are also in the 1976 Constitution. So in effect, Sat was saying that based on the new remedy which the Constitution gave to him, he was asking the court to declare sections of the Sedition Act which define sedition and which define the offense and the intention of a seditious offense, to declare the act unconstitutional, to declare those provisions of the act unconstitutional. This is an important judgment because the law of sedition in Trinidad and Tobago, as stated in the Sedition Act, is one of the colonial laws which have been used by the police since independence to prosecute persons who have been outspoken against governments. This was the law which was used to arrest and prosecute Tubal Uriah Buzz Butler, to charge him and to jail him. This was the law, as I said, which was also used in India to arrest and jail Mahatma Gandhi. This is an important judgment because, having regard to the provisions of the Sedition Act, the police did not have to prove that a person, in making statements and criticizing the government, intended to incite violence or public disorder. The police merely had to prove that in order to lay a charge, to show that the person made speech which brought the government into hatred and contempt and which caused disaffection against the government. Many politicians and persons in public life face the wrath of this law. Many trade unionists face the wrath of this law, and in some cases there were jail sentences. And I said this law was in Trinidad and Tobago since 1920. When I appeared in the Privy Council, and I want to pay tribute to all the lawyers who appeared with me in the Privy Council, including Mr. Taklar Singh, Mr. Stefan Ramkisud, Mr. Rambali. I was led by Mr. Peter Knox, King's Counsel in England, Mr. Rob Strang, and I don't know if I forgot anyone, and Ms. Ria Khan. When I appeared in the Privy Council, I wanted the judges to understand what really was the problem with these laws and how the people of Trinidad and Tobago reacted to these laws. And what I did, I asked them leave, and I quoted the words of two Calypsonians. The band Calypsonian, King Radio, and I recited the words to their lordships. And the words that he sang in those days were, "Believe I warning the rich and the poor. Be careful, friends, today from this seditious law. If you talk without defense, you have no evidence. They mean to license him out. They don't want me to talk. But you got to know, friends, what you're talking about. And you're sure to pay damn dear for your mouth. They mean to license him out, and they don't want to talk." I also decided to tell their lordships about the mighty Sparrow, the king of Calypso in Trinidad, who also sang a song about the sedition laws in Trinidad and Tobago. And what the mighty Sparrow sang, "Oh, you better put your tail between your legs and play it cool, cause anything you say, we're going to call it ridicule. The laws must change up, yes, but Lord, this one too fierce. The people of a country shouldn't afraid to talk their mind. If you're guilty here, it's straight jail without a fine. Betrayal of the people's trust to me is much more dangerous than what they're talking about. Sedition, careful, careful, how you talking. Sedition, careful, careful, where you walking. Plain gesticulation is straight apprehension in police detention charged with sedition. That gives you an idea of how the people and the pulse of the people thought about the sedition laws in Trinidad and Tobago. SAT has, by this judgment, which is given by the Privy Council on the 12th of October, got the Privy Council to change the law in Trinidad and Tobago. What the Judicial Committee of the Privy Council did was to effect reform by using the common law. The Privy Council held that the words which were to be implied in the definition of the offense of the act. And what the Privy Council did was, I would show you from the judgment, they said that you must imply, and that is from the highest court, any court construing the sedition laws must imply that the definition includes an intention to cause violence or public disorder, even though it is not there in the act. And courts have that power by the common law powers to interpret a legislation to even say how it should be read. This victory of SAT is even more important because the legal hurdles he had to cross was difficult. It was difficult because he was asking for constitutional relief, and we had to overcome what was expressly stated in the Constitution of Trinidad and Tobago. The Privy Council held that we could not challenge the law to be unconstitutional because it was an existing law as defined by Section 6 of the Constitution of 1976. Section 6 of the Constitution of 1976 says, nothing in Sections 4 and 5 of the Constitution, which guarantees individual freedoms in Section 4 and 5, shall invalidate an existing law. That is a law which existed before the Constitution came into force. The Privy Council held that the Sedition Act was a law in force at the time when the 1976 Constitution came into force. It had legal effect in Trinidad and Tobago, and based on Section 6 of the Constitution, they do not have to decide whether the law was constitutional or not, because by that section, no one could challenge it. In order to answer this defense, however, in the Privy Council, we argued on behalf of SAT that this definition of the sedition offense in Section 3 and 4 of the Sedition Act was vague, that it lacked certainty. It did not qualify as a law. It did not have the characteristics of a law. And therefore, if it did not have the characteristics of a law, Section 6 does not apply, because Section 6 talks of an existing law. And if it did not satisfy a law, it cannot be an existing law. The Privy Council did not agree with us with that, because the Privy Council said Section 6 expressly stated any law which had the effect of a law in Trinidad and Tobago. So the Privy Council cannot go into deciding and examining the qualities of the law to determine whether it had legal effect, because the Constitution in Section 6 says that any law which had the effect of a law in Trinidad and Tobago was an existing law, and therefore, since it was an existing law, it could not examine the constitutionality of the law. But we also relied on a textbook, a legal textbook, written called The Fundamentals of Caribbean Constitutional Law by Tracy Robinson, Bulkan, and Adrian Saunders, who is the president of the Caribbean Court of Justice. And what the authors in that book stated, that in respect of the Savings Law Clause, that same section, if the law does not qualify as a law, to meet the requirements of a law, such as certainty of the law, then it could not be an existing law. So we had the authority of this book, and we also had the authority of a decision of the Caribbean Court of Justice in the case of McEwan, in which the Caribbean Court of Justice held that if an existing law did not have the qualities of a law, it could not be an existing law. The Privy Council, however, held that they could not agree with that submission because the Judicial Committee of the Privy Council, in a 9-member panel in the case of Chandler, which was decided in 2023, had decided that the savings law clause in the constitutions had legal certainty, and if they had to hold that it did not have legal certainty, that in itself would create uncertainty in the law. So we could not get the Privy Council to reverse that decision. So therefore, our point in which we said that the sedition laws violated the Constitution of Trinidad and Tobago, Section 4 and 5, was dismissed by the Privy Council, no constitutional relief, because they held that this was an existing law. And the points we raised about the Caribbean Court of Justice and the decision of the Caribbean Court of Justice, and if the law is not, it doesn't qualify as a law, the Privy Council did not agree with us. What the Privy Council did, however, the Privy Council examined the development of the sedition laws throughout the Commonwealth and then considered our submission with respect to the uncertainty of the law. So we had argued before the Privy Council that when you consider the history of the sedition law and how it was developed by Supreme Courts in the Commonwealth, some of the Supreme Courts in the Commonwealth implied into the law, into the definition of sedition, the intention to incite violence and to cause public disorder as an essential ingredient of the offense. We showed that the Commonwealth jurisprudence, including Britain, did not agree with the definition of the sedition laws in Trinidad and Tobago. The sedition offenses were introduced in England in the 16th century against persons who use words that urge insurrection against lawful authority. There were frequent prosecutions for seditious conduct and the use of seditious words. Over the next 3 centuries, the speaking of inflammatory words and conspiring with others to incite hatred against the government and public officials and public authority were known as seditious offenses. In the early days, the common law concept of sedition did not require there to be an intention to incite violence or disorder. But changes came. The Australian Law Commission and the New Zealand Law Commission reviewed their sedition laws, which were the laws inherited from England as Trinidad and Tobago. And they found that these offenses were very antiquated, and they had an antiquated view of the relationship between the state and society. And they stated that the law of sedition should be reformed. The New Zealand Law Commission took a similar view, and the New Zealand Commission stated, and I quote, "In a democracy, the democratic theory is that people govern themselves. It is hard to see how or why speech uttered against a government should be a crime, not in a country which values free speech," end of quote. During the 19th century, the English common law began to include a requirement that there must be an intention to incite violence. The judges without Parliament decided to instruct juries that they had to consider whether the publication was calculated to incite acts of violence. The first case that was done was in 1820 in the case of Burkett. In 1886, in the case of Burns, that was another example where the judges decided that if Parliament did not want to act, they as judges, they had the power to interpret the law to even include words in a statute. In 2009, the British Parliament abolished the offense of sedition. In the colonies, however, of the British Empire, the laws of sedition were enacted similar to those in Trinidad and Tobago. In 1962, the Supreme Court of India held in the case of Kedarnath Singh and the state of Bihar that the offense of sedition was not unconstitutional, but when properly interpreted, the offense required either proof of an intention to create public disorder or tending to cause violence. So we saw the trend in the Commonwealth where the judges were taking the law and reforming the law. In 2023, that is this year, the Law Commission of India did a report on the usage of law sedition and recommended that the sedition laws be amended to include the requirements decided by the Supreme Court in the Kedarnath Singh case. The Canadian law of sedition was considered by the Supreme Court in Canada in a case called Boucher and the Queen in 1951. And the court held that seditious intention was not exclusively defined in the statute, and that the intention which was required and necessary to constitute the offense of sedition must be to incite people to violence against constitutional authority or create public disturbance or disorder against such authority. An intention to bring the government or administration of justice into hatred or contempt or even disaffection against them was not enough to establish sedition unless there was an intention to incite people to violence against it. The Privy Council, also in the judgment in Satnaraj, decided not to follow one of its previous decisions given in 1940 in an appeal from the Gold Coast, then Gold Coast, which held that the criminal code of sedition was clear and unambiguous, even if it did not require the proof of violence or disorder. The Privy Council decided that that decision was made many decades before the principle of legality was recognized by the courts in England. If you look at paragraph 46 of the judgment of the Privy Council in this case, you would see what the Privy Council said about the sedition laws in Trinidad and Tobago. In paragraph 46, you would see that if you look at the last 3 lines, it is therefore far from obvious to the board that if the compatibility of the Sedition Act had to be assessed by reference to the facts of a particular case, it would be given the wide interpretation which the appellants contended must have given. We were the appellants before the Privy Council. Sat was the appellant. Vijay Maharaj was the appellant. Then for 47, to the contrary, the board is of the opinion that were such a case to arise, there would be much to be said for the proposition that applying the principle of legality, and quite apart from any constitutional considerations, the true interpretation of the act, that is the Sedition Act, is such that there is implied into it a requirement that there must be an intention to incite violence or disorder. Indeed, this appeared to be accepted on behalf of the respondent at the hearing before the board. The Attorney General representative, for the first time, when the case was heard, accepted that. So the law in Trinidad and Tobago since this decision is that the police cannot prosecute an individual, whether he's an individual or a member of the media, for the words used or the publication of words used, unless they can prove that from the words used there was intention to incite violence or public disorder. In other words, publication of mere words which convey hatred to a government, disaffection to a government, or hostility to a government or lawful authority is not enough to establish an offense of sedition. Put it another way, if Sat Maharaj was alive today and he had said the same words that he said on his radio program, the police would have had no authority to go and execute a search warrant. They would have had no authority to take his recordings from the office, and they would have no authority to prosecute him, because the law as decided by the Judicial Committee of the Privy Council, which is the final court for Trinidad and Tobago, is that the definition of sedition and sedition offense in the Sedition Act is deficient, and the courts have implied how to make it a complete offense, in that you had to prove an intention to cause violence or to cause public disorder. The second good benefit of this judgment is that although the Privy Council decided that Section 1 of the Constitution cannot be used by a citizen or anybody applying for constitutional relief, because the provisions of the Sedition Act were in effect, it was in effect being alleged, violated Section 4 and 5 of the Constitution. So the Privy Council held that you cannot use a case which you could not bring because it could not pass the hurdle of an existing law to challenge it under Section 1 of the Constitution. But the Privy Council decided in paragraph 83 of this judgment that Section 1 of the Constitution gives an opportunity for there to be further challenges of state action or state laws on the ground that it offends Section 1 of the Constitution, that Trinidad and Tobago is a sovereign democratic state. At paragraph 83, at the bottom of paragraph 83, although the board accepts, as explained above, that Section 1 imports certain substantive requirements additional to those in Section 4, it remains the case that in those sections which set out the detailed provisions in the Constitution regarding the protection of freedom of speech. So what the Privy Council is saying, that if you come in with a violation under Section 4 and 5, you cannot use Section 1 of the Constitution. So let's say that in Trinidad and Tobago, there is an existing law which does not contravene Sections 4 and 5, but which contravenes Section 1. According to this judgment, someone can file a constitutional motion to challenge that law. Let's say, for example, there's a law after 1976 which violates Section 1 of the Constitution. It is inconsistent with Trinidad and Tobago being a sovereign democratic state. This judgment gives to the people of Trinidad and Tobago the right to go to court to challenge that law or to challenge even the executive action, legislative action, or judicial action. Because I want to tell you, and you're representatives of the media here, the state of Trinidad and Tobago act under three arms: the legislative arm, the judicial arm, and the executive arm. The constitutional right to obtain redress under the Constitution is if any of those arms of the state, whether it is the judicial arm whether it is the executive arm or the legislative arm, violate your right, threaten to violate your right, or is violating your right, or if any one of those arms act inconsistent with Section 1 of the Constitution, the citizen is entitled to go to the court to get redress. Now, in closing, I consider myself to have been very fortunate and privileged to have had the fortune to appear in a lot of groundbreaking cases in Trinidad, landmark cases, cases that have created precedent. For example, as a young lawyer, it used to be said that whatever the judicial arm did, you could not go to court. You could not challenge it. So when the judge imprisoned me for contempt and people came to me to ask me to apologize, I said, I'm not apologizing. I'm going to fight this. Because if I apologize today, every lawyer in Trinidad and Tobago would have to apologize. And what I did, I challenged the seat. I challenged it and I said that the judicial arm is accountable to the courts. It went to the Privy Council and the Privy Council held that even though a judge is immune from you suing him, if the judicial arm of the state violates the Constitution, a citizen is entitled to redress. I want to tell you today that this is one of the most important landmark decisions in Trinidad and Tobago. I'll tell you why it is. This Sat Maharaj case is one of the most landmark decisions in Trinidad and Tobago. Because a government could have used the Sedition Act to oppress the media, to oppress free speech. It was very easy that if the government had control of the prosecution process, and I mean any government, to be able to use that section, the Sedition Act, to in effect harass the media, harass activists, harass trade unionists. And the reason why this is an important law and one of the most important landmark decisions in Trinidad and Tobago, by the decision of the Privy Council, they cannot do that because they would have to prove that your speech, either an individual or the media, the speech said or published incited violence or incited public disorder. And that would be very difficult to prove. So therefore, this judgment has enhanced the freedom of the press, has enhanced the freedom of speech, and has enhanced the freedom to express political views. This judgment also gives a new remedy, a new avenue of a remedy for the people of Trinidad and Tobago to challenge the unconstitutional actions of the state, whether it is the judicial arm, the executive arm, or the legislative arm of the state. They can use Section 1 of the Constitution to say that it is inconsistent with Trinidad and Tobago being a sovereign democratic state. Thank you very much. I hope I have explained this case and you understand it very well. Thank you very much.
Thank you, Mr. Ramesh Lawrence Maharaj, Senior Counsel. Let's just give him a round of applause again for that presentation. Before I go to the thank you part of it, the vote of thanks part of this press conference, members of the media who are gathered here, any questions for Mr. Maharaj?
Hi, Vanessa Cutting, TV6 News. I'm struggling a bit with the basis of the argument that was carried to the Privy Council, simply because I'm hearing a lot of citizens should be allowed to speak out against the state, etc. So that sounds like what the argument was founded on. But as per my recollection, the sedition charge was brought against the deceased Maharaj due to statements that were inflammatory against a particular community. So I'm trying to figure out the correlation between the case that was carried to the Privy Council and the judgment.
Well, neither the High Court or the Court of Appeal or the Privy Council held that the statements Mr. Maharaj made constituted sedition. The case was argued and determined on the basis that whether the law was unconstitutional, whether the sedition offenses were unconstitutional. And as I said, the Court of Appeal held that the law was constitutional. The High Court held the law was unconstitutional. The Privy Council held that they cannot examine the constitutionality of the law because it was an existing law and it was saved, so therefore it was constitutional. But they decided that under the common law, under the powers they have, they could determine whether the definition of sedition met the requirements of the common law. And they held it did not meet the requirements of the common law. And therefore they had the power to imply into the definition of sedition that in order for anyone to establish the offense of sedition under the laws of Trinidad and Tobago, you have to prove an intention to cause violence by the words or intention to cause public disorder. So that the statements Mr. Satnarayan Maharaj made, all the people may disagree with it, it did not constitute sedition. And there is no decision that said it constitutes sedition. But the most important part of this development of the law is that if the police want to use this sedition law, they cannot only satisfy themselves as to what is in the statute in black and white, they also have to satisfy the intention to cause violence or public disorder. And if they can't satisfy that, they wouldn't have a warrant, they wouldn't have a prosecution, as you would have seen that the judges in even directing juries would tell the jury that if you don't have that, you cannot prove the offense.
Right. So is it that you're calling now for the state to make certain amendments to the Act?
No, the state doesn't have to take any measures. It doesn't have to go to Parliament. Parliament has to obey that law. The judges have to obey the Privy Council law. The courts have to obey it, and the police has to obey it. It is not to say that the Privy Council recommend that Parliament does something. The courts of Trinidad and Tobago, the High Court, the Court of Appeal, the Privy Council, has the common law power, not statutory power, common law power in interpreting a statute to say whether you should have an extra word in the statute and what you should have in the statute. That is the power given to judges, and that is how judges develop the common law. So what the Privy Council said, we cannot give you relief because your constitution says an existing law cannot be challenged. We cannot give you relief because you're challenging the existing law under Section 4 and 5, and Section 1 of the Constitution does not permit you to do that. But what we can do is that we could give you common law relief and hold as held in several parts of the Commonwealth. You cannot have a sedition offense without having the intention to cause violence or to cause public disorder. I hope I have explained it. Yeah. Okay.
So unless it is proven that certain actions were taken because of certain statements, then it can't be upheld, is what you're saying.
If action has to be taken in respect of those statements that Mr. Satnarayan Maharaj made now, it would be unlawful for the police to do it.
No,
you
I meant
understand?
if someone were to make inflammatory statements, right? And then certain actions were to ensue following these statements. You're saying now that unless it can be proven that those actions were because of these statements, that it cannot be considered seditious.
Okay, I think I understand. Yeah. Even if you use inflammatory statement against the Prime Minister, against the Leader of the Opposition, against the Parliament, against anybody, if what you say, you do not incite violence, you do not say, well, I call upon the people to come and mash up the place, right? Or public disorder, break up the place. Mere speech is not an offense of sedition. Mere publication of words is not a seditious offense. In order to constitute a seditious offense, since the 12th of October 2023 in Trinidad and Tobago, You have to prove that your words or the words of the media published intended to incite violence and disorder.
What legal provisions are there to mitigate against persons making inflammatory or reckless statements?
Well, I can't think of any law in Trinidad and Tobago which prevents individuals from making inflammatory statements. There may be a civil action for defamation, but any criminal offense, because you have to understand this, freedom of speech is one of the most important rights in a democracy. And the principle is that you are given very wide latitude to talk what you want unless you offend some law. Now, it may be under the Equal Opportunity Act with respect to race and etc. There may be some provisions particular to that kind of thing. But it is not sedition. And sedition is a serious offense because if you are convicted for sedition, you could spend, I think it's 2 years in prison. And if you're convicted on indictment, it's 5 years in prison and I think $50,000 fine. So this is a serious offense. Okay?
Hi, just one more question. Joshua Simongal from Guardian Media. Mr. Lawrence Maharaj, in your opinion, is there room for civil action retroactively? Let's say if someone was arrested and apprehended by the police, but based on this judgment, it's retroactively ruled to be...
I'm sorry, could you speak a little louder?
In your interpretation, or legally, is there room for retroactive civil action by people who would have been arrested on sedition charges and maybe believe they had their rights infringed constitutionally?
You asked a very important question. If it falls within 4 years, if what happened, if the violation, if the arrest or the imprisonment or the search of the property occurred within 4 years, you will have a cause of action because you always have to file your action within 4 years of the event on which you rely upon to bring the action either in tort, negligence, or if it's a constitutional right, you don't have a limitation period, but if you delay too much, you can be denied relief. But the fact that this decision was given in 2023, if there's a constitutional motion, a court would be hard-pressed to hold that there is delay because it's only recently decided that you may have a right to go to the court. So the answer is that yes, if it falls within the limitation period of 4 years, you can go to the court on the basis of the judgment given by the Privy Council.